This isn't just a parking lot dispute gone wrong. It's a case that exposes a chilling level of recklessness, and possibly something much darker. A mother, a school drop-off, and a man still on a scooter years after the incident. Today in this courtroom, we're watching the fallout of an event that shattered lives, an alleged pattern of aggression involving a car used like a weapon. What really happened that day? Was this a tragic mistake or something far more deliberate? You're about to hear from the victim, raw, emotional, still healing from multiple surgeries. And then a judge who doesn't hold back. She questions the prosecution's charges, challenges the defendant's attitude, and even considers whether mental illness or prison is the only way forward. This case has it all: legal drama, raw testimony, and a final twist that might just leave your jaw on the floor. Buckle up, you don't want to miss a second of this breakdown.
Plaintiff witness is present in person. I understand that probation did contact Mr. Reeves, and he did give a victim impact statement on page 4. So I'm going to ask the court to just review that victim impact statement, Judge, and Mr.
I don't have a.
Let's pause right here. The prosecution recommends 12 weeks of anger management, not 6, and pushes for increased community service. Why? Because this wasn't just reckless driving, this was targeted, a pattern, and that distinction could dramatically change how this case is viewed in civil or criminal court. Pay attention. Every amendment to sentencing here signals that even the state thinks the original recommendation was too soft.
That needs to be made at this time, Judge, because I never spoke with Mr. Reeves after the plea was taken, so I don't have any receipts or anything for restitution, so I would just defer to Mr. Reeves for that. But other than that, Judge, there's nothing further from the people.
Mr. Reeves, would you like to give a victim impact statement?
I would.
You may.
Thank you, Ms. Bryant, Judge Bryant, if you would allow me to not only submit the paperwork, some other papers, but I have a number of extra bills that are still recurring, as well as treatments that still need to take place because of.
This is where the emotional weight hits hard. Mr. Reeves, the victim, isn't just reading a statement. He's reliving years of pain. Medical bills, lost income, surgeries, videos, photos. He didn't come to play, he came to prove. His pain is tangible, and he's not asking for revenge. He's asking for recognition, for justice that doesn't feel like a footnote.
Just give me a moment to explain what happened. Miss Green was asked repeatedly to drop her 8th grade son off to the middle school door at John R. King. After 4 or 5 times of Miss Green pulling her car all the way up to me while I'm taking children out of their cars and walking them up to the sidewalk, Miss Green purposely drove around all the parents in line waiting to drop their kids off. And she repeatedly pulled up on me with her car. After the first few times, she was verbally warned. She was asked the first time to please stop. And I even gave her directions on where to drop her 8th grade son off. But she repeatedly kept driving around the parents that were in line and purposely pulling up on me in the parking lot with her car, to the point where this last time she was unable to stop in time, and I ended up having to push off.
Did you catch that? He says Miss Green repeatedly drove up on him, despite warnings. This wasn't a one-time lapse in judgment. It was a recurring act of defiance. And that changes everything. If she had been told to stop and kept going, that's not negligence, that's aggression. Question for the audience: would you feel safe in that parking lot? Should this be charged as more than a misdemeanor?
CD. Miss Green was asked not to even come to the school. We even had to go through the process of getting Miss Green banned from the school because she kept doing reckless actions towards me. I don't know no other way to try to ask for reconciliation, because the time that I'm still suffering I'm on a scooter right now, Judge. I'm still getting ready to go through physical therapy. I just had my last surgery where my ankle was fused because of Ms. Green's action. I heard you all say 1 week of probation or something else, but Judge, I honestly believe that there needs to be more accountability to Ms. Green's actions. This happened back in 2019. It's June 2023. I'm still suffering from Ms. Green's actions. I am asking, and I'm willing to submit these papers with some of the weeks that were lost in my work, where I had to take off because of surgeries and I was denied workman's comp with DPS. I'm still paying everything out of pocket. I've lost my other job and streams of income, not only speaking, but traveling and making sure that I can get to my other responsibilities with doing youth consulting all around the country. Ms. Green's actions have changed my life completely. I don't know any other way to express myself. And please just forgive me if I'm sounding emotional, because I am. This is my first time even coming close to even having an opportunity to address this situation in a professional manner. I'm still suffering from this injury that Ms. Green caused. I'm asking, Your Honor, that it's just not probation and anger management, but just as I had to sit still and recover for years now, I'm asking that Ms. Green suffered, jail not suffer, but is.
This is the breaking point. Mr. Reeves, still on a scooter, pleads with the judge. I'm still paying out of pocket. I lost my job. I'm in pain. I need your help. His voice cracks. He fights back tears. This isn't just testimony, it's trauma. And it leaves the courtroom stunned. Ask yourself, is anger management really enough here?
Ms. Green was asked to stop with the reckless foolishness that she continued to display at John R. King. That's my place of work. This is how I make my living. And for her to come and just continually not only disrespect the school, not only disrespect the kids, but put myself and the kids in danger. Yeah, I don't know any other way to express this, but there has to be some kind of accountability, because the actions that Ms. Green took, I don't know what else to say, but the best way to stand up to a bully in a situation is to say enough is enough. So, Judge Bryant, I don't know what else you would need from me. I have paperwork, I have pictures as well as videos. But please, I'm asking you, do not let this situation just be a slap on the wrist. I am still suffering. This is going to be this has been a life-changing situation where I am affected for the rest of my life. My ankle is now fused. It took me, I started at 3 a.m., just for example, I started at 3 a.m. this morning because of the rain. Judge Bryant, what I'm asking you is, Ms. Green can never pay me the amount of money that I've lost. She can never replace the amount of time that I've lost, the engagements that I've lost, the time with my family, friends, as well as the schools, as well as their different positions that I now have to try to readjust my new way of life now. I'm asking, can you please speak up for me in a tangible way where Ms. Green will know that this is not okay at all. I need your help. I need justice. That's what I'm asking for.
All right, thank you, sir. Ms. Stevenson, anything on behalf of the defendant?
Thank you, Your Honor. Because of the nature of the plea, Ms. Green was advised not to make a defendant's statement, Your Honor, and that was her right not to do that. We did offer a no contest plea, anticipating that Mr. Reeves might try to avail himself of civil proceedings in order.
Now listen closely to the defense. They lean heavily on her no prior criminal history and a no contest plea, possibly prepping for a civil lawsuit. But notice what's missing. Remorse, empathy, even a basic acknowledgement of harm done. The strategy here is legal survival, not emotional accountability. And it's not landing well with the court.
But we're here charged with a misdemeanor, convicted at this point of 2 misdemeanors. Ms. Green with no prior criminal history, employed at this time, having no contact with the complaining witness, having no contact with the location of the incident, ready to accept responsibility for her actions. We trust this court to fashion a sentence which does give Mr. Reeves justice. There is another form whereby he may be made whole, even though Ms. Green does understand that because of the no contest plea, she is expecting some type of restitution, Your Honor. But there is a forum whereby Mr. Reeves may be made whole. And Ms. Green has no prior criminal history. In addition to deterrence and rehabilitation, definitely I believe is one of the goals of this court. And I don't see any reason why the sentence recommended by the probation department would not give the court, should Ms. Green comply with those conditions, assurances that she won't be back here with these types of charges in the future. So I'm asking the court, if it's not inclined to follow the probation department's recommendation, to follow Ms. Ritter's recommendation, Your Honor. I did just want to point out, I know that in her conversation with the probation department, Mr. Farmer was left with the impression that Ms. Green was somewhat evasive. And again, I would ask the court to hear my reason for that, which again is the advice of counsel, because this was a no contest plea, that she should definitely not try to hold back any information that the probation department would need to make a sentencing recommendation, but just not to get into the facts of the case because it was a no contest plea. Ms. Green has been completely cooperative with me throughout this entire process, ready to bring this matter to its lawful conclusion, hasn't violated any of the court's conditions, Your Honor, with regard to having no contact with the complainant. And I'm asking the court to follow the people's sentencing recommendation.
Would Ms. Green like to make a statement on her own behalf?
Ms.
No,
Green?
ma'am.
All right.
No.
Well, Ms. Stevenson, as you can see, Mr. Green is sitting on the screen. Mr. Green, can you unmute and just put your name on the record and tell me if you're related in any way to Nicole Green?
Yes, Your Honor. No, I am not related at all.
All right. And your name for the record?
Yes, Demetrius Green, Specialty Court Case Manager.
All right. So when I read the pre-sentence report and then when I
Watch this shift, the judge is stunned. She openly questions the prosecution's decision to undercharge the case. And when a judge says on the record that this may have warranted a felony charge like vehicular assault, that's serious. The energy in the room shifts. This isn't routine anymore, it's personal.
on behalf of the warrant unit in the prosecutor's office. Now, I don't know what process they go through when they issue the warrant, particular warrant. I was looking to see if this had started out as a felony, right? I was looking to see if it had to start out a felony, and it didn't. And then I'm reading, and then I'm listening to Mr. I'm gonna tell you his name in a minute. I saw it on here. I'm listening to Mr. Reeves, and I'm saying, well, why did the prosecutor's office charge this as something having to do with an accident, as opposed to a felonious assault with a vehicle? That's what I was thinking. I was like, You know, this should be, I don't know why you shaking your head. Yes, Ms. Green, because that's against you. Felonious assault, I think that's like a 10-year felony or something. I don't know. And then this one of them, okay, so I'm saying that for a couple of reasons. So I don't know what the process is that the warrant office of the prosecutors, the warrant division of the prosecutor's office goes through. I feel like if they had interviewed Mr. Reeves, that maybe they would have charged differently. That's how I feel. That if they had interviewed Mr. Reeves, that perhaps they would have charged differently. Because I'm sitting here saying it started out as failing to stop at a personal injury accident, which also says to me that she hit him and ran. A hit and run. So she hit him and she didn't stop. And then, you know, y'all do what you do and negotiate it down to failing to report an accident. Now, I'm going to say that I'm a little disheartened by the way it began in terms of charging and the way it ended in terms of charge. And if what Mr. Reeves said is true, this was sorely, severely undercharged by the prosecution. And
And now the hammer drops. This was severely undercharged, the judge says. She accuses the defendant of being aloof, dismissive, and completely lacking remorse. She even questions if Miss Green is mentally fit or should be sent to prison. This is no longer a courtroom formality. It's a reckoning, and it gets even more intense from here.
Miss Green could care less that she is aloof. She is not contrite. She is whatever she is. And I am feeling like I almost am not going to accept this recommendation and give her an opportunity to go back up to the original charge, if she chooses to. But I'm also, the reason I asked Mr. Green to come on is because I'm thinking to myself, a person has to be almost mentally ill for me to hear what I heard today. You know, I always say this right here. And I've even, I think, told you all this story. I don't know if I've ever said it on the record, but I know I've told it to the attorneys, like off the record when we're having our little, you know, post-court chat, of how I almost hit somebody and how it devastated me, how I was crying at the thought of almost hitting somebody. Yet Miss Green appears on my screen and she did hit somebody. And if that baby shake her head, no, one more time. If she shake that head, no, to the left or to the right. No, one more time. And that's exactly what I'm talking about. That right there is exactly what I'm talking about. Exactly what I'm talking about. And so I want to believe that the reason she is acting in this way is because she has some type of mental illness or mental disorder that she needs to have addressed by the specialty court which is why I brought the specialty court coordinator on here. There, according to her self-report, she doesn't have a history of mental illness. But everything that I see says that she either is mentally ill or she needs to be in prison. Let me tell you that. So from what I see, I say she's either mentally ill, has some type of mental disease or disorder, or she needs to be in prison, and the prosecutor should have charged her with, at least at a minimum, felonious assault. Perhaps they should have charged her with assault with intent to do great bodily harm less than murder. Or perhaps they should have charged her with assault with the intent to murder. So while she coming on here with this little lackadaisical attitude, I had to admonish her this morning about her, how she's standing, how she putting her ear up to the phone and whatnot. It's ridiculous, it's appalling, and it's offensive. And I agree with Mr. Reeves. I agree with Mr. Reeves. I agree with Mr. Reeves. But where I disagree with Mr. Reeves is that this is simply a misdemeanor. It's a misdemeanor. And it's only punishable by up to 93 days in the Wayne County Jail. Now she's on the verge of getting 90 of the day.
Here's the problem. It's still just a misdemeanor. The judge's hands are tied. The max sentence, 93 days, that's it. So she finds a workaround, ordering a mental health evaluation before sentencing. But is it enough? You tell me, is justice being served here? Or has the system failed both the victim and the truth?
To submit to a mental health evaluation before I will agree to her sentencing. You see what I'm saying? She done raised them eyebrows already at the top of a mental health evaluation. Was the one that hit him. And so your attitude sucks. Who has now had to endure surgery after surgery after surgery. If I was the cause of that, if I caused that to somebody, whether I intended it or not, I would be contrite. I would be so sad and sorry. I would be like, I am so sorry. If I didn't say anything else, notwithstanding a no contest plea, notwithstanding that Mr. Reeves may sue me civilly, I would say, I'm so sorry that happened to you. I'm so sorry that you have had to endure these surgeries. You're offensive, Ms. Green. Your demeanor with respect to this situation, it's offensive. I'm going to let her talk to Mr. Green. It is my intention, as I indicated, at a minimum, she's going to have to submit to a mental health evaluation. Because if she passes that mental health evaluation and they tell me, no, she just whatever, and she doesn't need mental health treatment, because there's nothing in her report that says.
Rare moment here. The judge compares Miss Green to herself. She recalls how even almost hitting someone once left her in tears. But Miss Green, who actually hit someone, shows nothing. No apology, no emotion, just silence and denial. The contrast, brutal, and the message, crystal clear, your attitude in court matters.
On to jail. And I'm going to write a letter. I'm going to find out from the State Court Administrator's Office, if it is inappropriate for me to express my displeasure to the prosecutor about how they charge this case. It's appalling to me. It's appalling. Based upon the police description of the incident, it's appalling. I'm going to send Mr. Green and Miss Green to breakout room.
Judge Bryant, if I may interject. So if Miss Green is self-reporting that she does not have any mental issues,
She don't qualify.
Yeah, that would be a non-qualification.
Yep. We can't check it out.
So I do not have the ability to make a clinical assessment. That would be required by a licensed practice assessor. We do have a clinical assessor on our team. However, she is not in the office today and she is working from home. So I'm not sure about her availability in this moment, but if we would like to schedule something with her, we can make that happen.
Okay, yeah, let's do that. All right, so this is what I'm going to do. I'm going to adjourn the sentencing. I want Ms. Green to submit to a mental health assessment. And then I'm going to set the sentencing for in person. And that in-person sentencing is going to be Mr. Green. How long, like, what do you know anything about the availability?
So I do know in this next week, we will be traveling to a conference and we will be gone all week. But however, the week following that, we should be available that Monday, specifically because I know Tuesday is going to be a holiday, July 4th. But yeah, we can probably get her done that Monday. Okay.
So let's see if we can schedule her for that Monday. And then I'm going to adjourn the sentencing to the following. Well, I want to make sure it's a day that I'm definitely going to be in person. Ms. Stevenson, do you know anything about the Hickman trial on the July the 10th? There is a 12 noon check-in. Well, I don't know the charge.
That's what you want to know what the charge is, Judge?
It's a bench trial.
Here's your final countdown. The judge sets a new sentencing date, orders a mental health evaluation, and drops one last bombshell. If she doesn't show up, $30,000 bond, GPS tether, jail time. This isn't just legal procedure anymore. It's a last chance. Think she'll take it seriously now?
I don't even know that attorney. I'm going to set the sentencing for July 11th. I'm going to adjourn the sentencing.
Excuse me, huh?
Yes, sir.
I was trying to see if I can, is it possible to do the following week? I wanted to know if I can be at the sentencing. I have a summer camp. It's a prior engagement that I run in Lake City, Michigan. It'd be a huge ordeal if I had to travel back down to Lake City.
So that's that week I was just talking about?
Yes, ma'am. I do. It starts the 8th through the 15th, and I'm done the 15th.
Okay, thank you. All right, well, then I'm going to set the sentencing for July the 17th. No. I'll do it on the second day of the trial, July the 18th. That's at 9:02. And it is in person. So the assessment should be complete before then, and then we can address moving forward. Additionally, I'm going to indicate that should Ms. Green fail to appear on July 18th for the sentencing, she looked like she just froze up because she was walking and moving, because that wasn't her same background just a minute ago. when I first looked down. This not the background I had. So she walking and moving, and now she doesn't have signal.
I can, I think the phone may have died, but I can get her on the phone so she can hear if that
Not if her
pleases the
phone
court.
died, but go ahead.
Okay.
Because I want her to hear that if she failed to appear, her bond is going to be $30,000, 10% plus a GPS restricted tether.
She'll be here, Judge.
All right. Well, I want to make sure she know that, but
It's just ringing,
I
Judge.
trust you.
This case started as a school drop-off and ended as a courtroom firestorm. Mr. Reeves walks with pain permanent, unhealed. The court struggles to balance mercy with justice. And Miss Green, well, she may soon face jail or a deeper psychological reckoning. So what do you think, was justice served? Or did the system fall short? Let us know in the comments. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts, and subscribe for more jaw-dropping courtroom breakdowns. You don't want to miss what's coming next.